Okay, folks, I think we're going to get started. Thank you all for coming. I'm Sue Joseph from International Student Services. We have a couple other people from our office here today. Erica Ford, a new advisor in our office, and I think Jeff Cox you might have seen out in the hall, maybe coming in. We're very happy today to have a wonderful guest here to speak with us, David Wilks, from a law firm that's in Ithaca, New York, which isn't right in Rochester. It's about 90 miles or so.
Yeah, not too far.
In Ithaca, Miller Mayer Associates, and he's been a good friend to RIT students over the years, has provided a lot of good advice to our graduates and to employers interested in hiring students. So we're very fortunate to have him here today. He's going to be talking about life after student visas, and I want to point that out to let you know that we're not going to be talking about optional practical training or academic training. The focus today is going to be life after F1 and J1 visas. Okay, so David, I'll hand it over to you.
All right, thanks so much, Sue.
Thank you, sure.
It's great to be here at RIT again. I just want to get a sense of where everybody's from. Who here is from, let's say, South America? Anybody here from South America? All right, we got one, great. Anybody from Canada, Mexico, or Central America? Okay. How about Europe? Great. Any from Middle East? Okay. Africa? Great. How about South Asia? Yeah. And then how about East Asia? Great. And then any Australians? New Zealanders? Okay. So we got a nice variety today. That's great. So we're going to talk about how this works, how immigration works. It is going to be specific to you as far as what your strategy is going to be. What works for your friend is not necessarily going to work for you because everybody has a different mission, everybody has a different goal, everybody has a different career path. And the one thing I want to start with, and this is sort of the theme overall, is what's going to help you the most with immigration is figuring out what your priorities are. So for some people, what they want is they want to come into the U.S., get a great degree, get some great experience at the position of their dreams, and then they might go home, right? They might want to go and set up a company back home. They might want to be transferred to some big employer back home, and that's totally fine. For others, they want to be in the United States. Maybe they have to be in the United States because of some political issue back home, or because they're from a class of individuals that is mistreated at home. And that's great too. It's unfortunate, but it's also, that's a valid strategy with immigration. And so if that's your strategy, it's going to be very different from the strategy of somebody who is going to just doesn't care whether they go home for a while or ends up at home. You're going to have different choices. Because the truth is, when it comes to U.S. immigration, there will be sacrifices, there will be choices, there will be things that you have to give up in order to get something that you want. And so to figure out what are the things you are willing to give up, it's important to know what is driving you, what is important to you. So you want to figure out where you are on that spectrum. Because maybe it's not one extreme or the other, maybe it's somewhere in the middle. And if it is, that's fine. You want to be able to know that so that you can make the choices that are appropriate for the career that you want to create. So just to give a little bit of an overview of what we're going to do, we're going to talk very broadly about U.S. immigration overall, sort of the forest as opposed to the trees. And then we're going to get into those trees a little bit. We're going to talk about the common temporary visas or non-immigrant visas that you all will be exploring as you graduate and leave RIT. Then we're going to talk about long-term residence, the green card, which is often the goal for most foreign nationals in the U.S. And then we're just going to talk about planning ahead a little bit. Miller Mayer is a firm down in Ithaca. We have attorneys in Asia as well. The great thing about immigration is it's a federal practice, so we can practice it anywhere in the U.S. And Ithaca is a beautiful place. If you haven't visited, you should. It's beautiful. There's a lot of great things to do there. Waterfalls everywhere. So we practice there, but we are able to work with anybody throughout the world, right? Because of communication and computers and phones and all teleconferencing and all sorts of things, we can operate basically with anybody anywhere. And this is what we look like. These are all the immigration attorneys at Miller Mayer, and we have a great staff, and we're happy to help people navigate the immigration system. So as far as what the U.S. immigration system looks like, this is a very, very, very simplified chart that explains how the U.S. immigration system actually works. So first are non-immigrant visas. Who here is in F status? Okay, do we have any J's? Okay, do we have anything else? So only F's and J's? Nobody's not an F or a J? Oh, what do you?
So like green card pending status.
Okay, but you're probably right now, you're probably an F or J right now, or are you in the
F1.
F1, okay.
I used to be J1 and now I'm F1. So
Okay.
which one I should?
Well, right now you're in F1 status. Yeah. Okay, so basically everybody is in some variation of F or J status. Those are all non-immigrant statuses. Those are temporary statuses. Non-immigrant statuses are limited in what you can do and where you can do it, right? So if you have an F visa, what you get is, when you enter the United States, is an I-94, and you'll see on that I-94 DS, or for duration of status. And what that tells you to do is go look at your I-20, and that I-20 is issued by RIT, and that tells you basically where you're going to school. It has your program of study, it has contact information for your school, and says how long your program is. If you're going to be pursuing OPT, it'll list that on the back as well, saying who you're authorized to do OPT with. And if you're going to travel, there's a travel notification on there as well. The I-20 controls basically what you can do in the United States. That's why it's very important to stay on top of things with ISS here, right? You don't want to do anything without talking to ISS first, right? That can get you into some trouble because non-immigrant status is very limited. You're limited to what you are authorized to do. With J status, you're looking at the DS 2019 instead. And so with DS 2019, it's going to list where your funding comes from, who's the sponsor of your program, what type of program you have, and then it's going to also list whether you're subject to something called the 2-year foreign residency requirement, which means that you are required to go home for 2 years before you can have HL or H/L status or a green card. We'll talk about what those things are. And that's notified on that form. It also has a travel legend as well, if you're allowed to travel. But basically, what is listed on that form controls what you can do. Again, you are limited in what you're able to do. As you move on to, say, H status, you'll find that that is location-specific, job-specific, even salary-specific, right? And if there's any changes to that, you have to get authorization for those changes. That's the life of a non-immigrant. That's why people don't like being in non-immigrant status, because it's a lot of limitations, and you'll often have to extend the status, so you're paying extension fees and all sorts of things like that. So that's why people want to move on past non-immigrant status into becoming a permanent resident, right? And so generally the way that you do that is through an immigrant petition, which we'll talk about later. That's the I-140, the I-526, the I-360, or if you're married to a U.S. citizen or related to a U.S. citizen, it's an I-130. Again, we'll talk about all of that in detail. And then if you're going to be a permanent resident, that's when you're a green card holder. They are actually green. They weren't always green. They changed them back to green because local law enforcement didn't think they were actual green cards because they weren't green. So now they are actually green. They are very, very patriotic. If you look at them, there's eagles and stars and stripes and all sorts of fun things. You can live and work anywhere in the United States, okay? That's the best part, right? So if you want to be an entrepreneur, having a green card is amazing because you can do whatever you like, right? There's no obligations to stay in that box of non-immigrant status. You cannot vote, you cannot serve on a jury, you cannot run for office. And also, you can still be deported, right? There's a slogan, it's part of pop culture in the United States from the 80s. Nancy Reagan was the first lady. She would always say, just say no to drugs. That's very, very important for you all. I know, not that you would, but U.S. Drug laws are extremely broad, and so if you're at the wrong party, you can get a drug possession charge, even if you weren't doing anything with that. But drug charges are extremely difficult to deal with, even if you're a permanent resident. So you want to steer clear of anything that is prohibited by federal law. So just be very, very, very careful. Because you can't break the law until you're a U.S. citizen, okay? So, not that you should become a U.S. citizen so you can break the law. That wouldn't be showing good moral character, which would prevent you from becoming a U.S. citizen to begin with. But the reason people become a U.S. citizen is, one, they want security for their kids, right? So if you have kids, and maybe you guys are too young to have kids, maybe not all of you, but
If you have kids that are not U.S. citizens, right, you can become a U.S. citizen by just being born in the United States. But if you have children that were born prior to you coming to the United States, oftentimes people want citizenship for those kids because they want them to be secure in case something happens in high school or something happens at a party, right? They want them to be secure. The second reason people become citizens is that they want to vote, right? Every time there's a presidential election, there's an influx of N400 applications because they want to become citizens because they didn't like the result of the last election every single time. So that's another reason people want to participate in their home society, right? And then the last is because they want a stronger passport, right? So some countries have stronger passports than the United States. Europe has passports that generally are a bit stronger than our own passport. But some countries have passports that are less strong, which require visas to more countries than the U.S. passport means. So people will want to become a U.S. citizen so they have that passport that doesn't require as many trips to foreign consulates in order to travel around, right? So that's why people want to become U.S. citizens. There are people that are not on this continuum, and that's not to say that there's anything wrong with where they are. It's just that they don't fit very well into these categories here. And that would be deferred action, DACA. That would be somebody that came over the border as a child or overstayed a visa as a child. And basically it's the government saying, well, we have too many people to prosecute, and you have very low culpability being a child coming to the US, so we'll let you stay. Because we just have too many people to process through the system anyway. Excuse me. So we're not going to focus on you. And then there's also something called temporary protected status. That's if there is a crisis in your home country. Sometimes the government will let people from that country stay as a humanitarian act. And of course, there are people that are undocumented, and you can become undocumented by violating your visa status, right? So that's why you want to be very careful and keep ISS in the loop of everything that you're doing, because you don't want to fall out of status. You don't want to become undocumented. Again, not because there's anything wrong with the individuals that are undocumented, but it does become more difficult to get you back on this continuum, which is where you want to be. So this is the typical immigration timeline. It more or less reflects what we were seeing on the other page. This is where you all will mostly be. So this is the student employee pathway. That's where most of you will be. You start on F or J visas, that's where you are. After that, you'll have optional practical training, which is we basically, in the United States, you've had an education, and now we feel that part of that education is the practical application of the things that you've learned. So the government allows you to do that for a year in every major, and then if you are in a STEM major, science, technology, engineering, math, and that's governed by the code that's on your I-20. If you're going to be working in one of those STEM fields, at 2 separate levels, right, you are allowed to have a 2-year extension. So what that means is that if you come for a bachelor's, master, and PhD, at 2 of those levels, you can do STEM OPT. There's also, if you're on J, it's called, I believe, academic training, where you are allowed to do some work, but it's not every field, it's not every program sponsored. So again, you want to talk to International Student Services to see whether you are able to do that academic training. Before your status runs out, so one thing that's going to sort of be a theme of this is sort of a strategy. You want to make sure that you're maintaining status in the United States. So before you run out of one status, you want to move to another. So if you are in optional practical training, if you're an OPT working, and you want to keep on working, before your OPT expires, you want to get into some other non-immigrant status that's work authorized. So that could be, and probably will be, the H-1B. But we're going to talk about that in detail. So generally, people are trying to get into H-1B status before their OPT expires. So we'll talk about how that works and how there's little extensions and things that you can do. Once you're in H-1B or some other status, that's when the question of what do you want to do with your life comes into play. If you want to stay for the long term in the United States, you want to start working on your green card, particularly if you're from India or China, where there are long waits for green cards because green cards are allocated by country of origin, right? So only 7% of each green card category can go to any one particular country of origin, right? So because of that, countries that are larger tend to have a longer wait, right? And that's to our detriment as a country, right? Because so many great achievements have come from people from India and China. And so There are legislative solutions that people are working on to try to see if they can fix that situation. But for right now, if you're coming from India or China, you want to be very cognizant of when you start that green card process, and you want to get your petitions in as early as possible to get your place in line. So that is a broad overview of everything we're going to talk about in this presentation. And so these are the questions I want you to keep in mind, though, as we go. Can you work? Right? That's very important. Some visas allow you to work, some visas don't. If you're an F or J status, you can't work unless you get authorization to do so. Generally, that's for on-campus employment, or it is for something called CPT, curricular practical training, that's related to your degree, or if it's something that gets you course credit. You don't want to do anything that gets you in trouble. So if you're selling an app on the App Store, that's problematic, right? Because that's creating work, right? You're getting money for a service, that's work. Or if you're selling a craft on Etsy, same situation. You want to be very, very careful and realize that this is, again, the sacrifice issue that I was talking about before. One of the unfair things about being an immigrant to the US is what your colleague and classmate can do without problem, you may not be able to do without causing you trouble. So you always want to be questioning, can I do this, and not take for granted that you can do everything that you want to do. Okay? I wish that wasn't the situation, but it is. And so from a security perspective for yourself, you always want to be looking out for yourself. You always want to know the laws and the rules as best you can. You want to always be questioning in your mind, can I do this? And while you have this great office of advisors here that are available to help you, ask, right? I mean, Sue, you probably prefer, and I'm sure you probably prefer to be asked in advance than how can I clean up this situation now?
Yes.
Yeah. So, can you work? It's a very, very important question. Next, who can you work for, and what are you allowed to do? Right? So even if you have work authorization, you may not necessarily be able to work. You may not be able to work for every employer, right? So for example, your H-1B could say that you're able to work for Kodak. That doesn't mean that you can also do things on the side or work for somebody else without authorization. How can you be compensated? Some visas require minimum pay. So if you are going to be an entrepreneur, maybe you can't afford the minimum salary requirements from the get-go of certain visa types. So you want to pay attention to that. And does my status limit my family members? So if you are married, some visas allow spouses to work, others do not. And that can be extremely difficult on people, right? 2 careers, one is on hold while the other pursues their career. That's a big issue, right? And so you want to be paying attention to that as you go along. These are the visas we're going to look at primarily. The ones that are most specific to you. We're going to spend the most of the time on the H visa, and there are no Australians here, right? So we can skip over that. And then, was there anybody from Canada or Mexico? Okay, so we'll skip the TN as well. But let's start with the H-1B. So the H-1B is the primary professional visa. There are 4 requirements for the H-1B. First, you have to be looking at a job that is in a specialty occupation, which is to say that the job requires a specific specialty of a bachelor's degree or higher, okay? So it's not that the job will take any bachelor's degree, it's that they will take a specific bachelor's degree, right? So if it's an engineering job, the job has to say require a degree in electrical engineering. It can't, for example, say a degree in business, finance, electrical engineering, or accounting, right? That's not a specialty occupation because you don't need a specialization in order to fulfill the job, right? If you have business administration as your degree, you want to get a specialty because USCIS tends to view business administration as a general degree rather than a specialized degree. So you want to be always looking at, is there a specialization that's involved there? You actually have to have the degree as well. That's the second requirement. So the job has to require a specialized bachelor's, and you have to have the specialized bachelor's. So there has to be a nexus there. Next, the employer needs to pay what's called the required wage, which is the higher of the wage that they're paying to all the other employees in the same position with equal experience, or what the Department of Labor says they ought to pay, okay? And there are surveys that your employer will follow. Lastly, if the job requires a license, you have to have that license. And in most cases, that won't apply. Most jobs don't require a license. So the advantages of an H-1B, if there's a 6-year duration, you can, if you stay outside of the U.S. for 1 year, it restarts your 6 years. If you start your permanent residence by the 5th year of H-1B, you can continue to extend your H-1B in perpetuity until you get that green card. There's no test of the labor market, so that means your employer doesn't have to re-advertise for your job to see is there an available U.S. worker. They're allowed to take the best worker available, presumably you all, as bright, amazing RIT students, are the best available. There are ways of changing employers that are easier and faster than other visa types. And there is some spouse work authorization currently once you get down the road towards permanent residence. Excuse me. There are also disadvantages to H-1B. Every employer that you have has to file their own petition, right? So an H-1B is employer specific, it's job specific, it's location specific, right? So if you're going to change jobs, the new employer has to file a new H-1B for you. Self-employment can be limited. So if you're going to be an entrepreneur, you have to show that there's an employee-employer relationship, which to put crassly means there has to be somebody that can fire you. So if you own the company, that becomes difficult unless you have what's called an independent board of directors. So you have to set those up. You have to plan for that in order to be able to be an entrepreneur. So it's not as flexible as, say, OPT, where as long as you're within the occupation, you can change jobs rather flexibly. With this, you have to have a different H-1B petition for each job, and those jobs have to qualify for H-1B. So if you decide that you want to change careers, and they say, oh, well, you've got a degree in electrical engineering, but, I see some experience here or I see that you have, merits in graphic design. That's not going to work from an H-1B perspective unless you have the equivalent of a bachelor's degree in graphic design. There are fees associated with it, and you can see those up there. Your employer has to pay those, or a third party can pay them as well. You cannot, right? So your employer can't require you to pay them, and you cannot pay them yourself. There are high levels of requests for evidence right now. So requests for evidence, or RFEs, are when the petitioner sends in the petition, so your employer sends in the petition, and USCIS comes back. USCIS is the adjudicatory agency. It's U.S. Citizenship and Immigration Services. They send back a request saying you haven't met the criteria, please send X, Y, or Z. And over the last few years, they've come up with new types of requests for evidence, new types of things that they're pushing for. They don't announce these in advance, they just announce them through their request for evidence. The problem is, of course, the law hasn't changed, right? But that's sort of the dynamic of working with an agency, that policies sometimes change, even if there's no law to justify the change in policy. And so when you have a less friendly sentiment towards immigrants, you see this more significant pushback, right? So that's been a problem lately, but we have still seen the vast majority of our clients have still had success with the H-1B. The biggest disadvantage is the H-1B lottery. How many people have heard of this? Okay, most of you, that's good. So the H-1B lottery, the way that this works is that every year there are 65,000 H-1Bs available for anybody that has a bachelor's degree or higher. If you have a master's degree or higher, so a PhD as well, from a U.S. institution, so those of you that are getting master's degrees and PhDs right here from RIT, you are all set. If you have a master's degree from Oxford, we don't want your bad English degree. We want only good, hearty American degrees, right? So you have to go into the 65,000 cap, right? So if you have a U.S. master's degree or higher, you get this extra 20,000. And the way that it works is that first they will do the lottery of the 65,000. So every petition that they receive during the first week of April, so it's the first 5 business days of April, they will put into a computer, and it will spit out 65,000 names. If you're part of that, you'll get a receipt notice. Those that are not successful, that have a U.S. master's degree or higher, are then put into a secondary lottery for 20,000. And what this ends up doing is it creates a system where if you have a U.S. master's degree, you've got about a 1 in 2 shot of getting through this lottery. If you have a bachelor's degree, it's probably closer to a 1 in 3, 1 in 4 shot. Last year there were 210,000 petitions for those 85,000 spots, okay? So that makes it somewhat challenging, right? So this is why you want to apply for the H-1B as early as you can. If you have 3 years of STEM OPT, you want your employer to file every single year, because if you have roughly a 1 in 3 shot as a bachelor's degree holder, odds are pretty good that if you file 3 years in a row, which you can if you have STEM OPT, you should be able to get one of those years. Now, it does happen that some people don't get them, and then you have to figure that out later. There are H-1B alternatives. But if you have the opportunity to apply, you should apply. You don't want to put that off. There are exempt employers that don't have to go through the H-1B lottery. So if you work for a university or college, so if you're going to go the academic route, your employer will not have to get an H-1B for you. If Sue really likes you and can hire you off this, and the university is willing to sponsor you, RIT is an employer that is CAP exempt. They don't have to they don't have to go through this lottery. There's also university-affiliated not-for-profits. So if you end up working for a healthcare facility that is connected to a university, then you are able to also get a CAP exemption, right? Also, not-for-profit research institutions. This could be a government institution, like a state government research office, as well as other types of not-for-profit research institutions. They also get CAP exemptions. Now, the issue for this is if you're in a CAP exempt job and you want to then go to a CAP subject job, you have to go through the lottery if you haven't done so already. There are exceptions to that as well. If you have a part-time CAP exempt job, you can also have a CAP subject job through what's called concurrent employment. But as soon as the CAP subject job goes away, in order to extend the CAP exempt job, you will have to go through the lottery. Basically, the trick is that if you ever have a full-time CAP subject job, you have to have gone through the lottery in order for that to be your only job. If you have any sort of CAP exempt job as well, and you have an H-1B for that CAP exempt job, that'll cover the CAP subject job, okay? So there are CAP exempt individuals. Once you've gone through the CAP, you are all set, right? At least during the 6 years, the 6 years that you have. If you end up leaving the US and restarting the H-1B, you're gonna have to go through the lottery again. But if you file your green card by the 5th year of H-1B, and you've already been through the lottery, you can keep extending that H-1B and have CAP subject jobs without having to go through the lottery every time. If you're employed at a CAP exempt worksite, so let's say that you decide to start a company right here on RIT campus, and there's some nexus between what you're doing and what RIT is doing, you can be CAP exempt that way. And then we talked about concurrent employment again, which is if you have a CAP exempt job and a CAP subject job, you can have both of those employers without going through the H-1B. Again, because as long as you have one CAP exempt job, that will cover the CAP subject job, okay? As soon as you lose that CAP exempt job, you're gonna need to go through the lottery in order to extend the H-1B for the CAP subject job. And then lastly, J1 shortage waiver for doctors. I don't assume any of you are medical residents, so that doesn't really apply to you. So we talked about this already. The lottery happens when there is an oversubscription. And as you can see, every year since fiscal year 2014, so that would be October of 2013, that's when fiscal year 2014 starts. So every lottery since 2013, or every H-1B filing period since 2013, there has been a lottery. If you see this period where there weren't lotteries, basically what happened, this is when, if you remember Lehman Brothers collapsed, maybe you don't remember, but Lehman Brothers collapsed in the fall of 2008. So the first H-1B period after that economic crash would have been this, the fiscal year 2010, which would have been through the 2009 filing period. That's what, basically whenever the economy goes down, that's when H-1B petitions go down, right? Because people aren't hiring as much. So that's basically what you see here reflected is when there's economic good times, there's going to be a lottery. When there's economic bad times, there is not a lottery. Also, another thing to keep in mind is this CAP gap. I imagine you talked about this in the F and J your talks, but basically if you are going to file for an H-1B and your OPT is expiring, as long as the OPT expires after April 1, the OPT will be extended automatically through CAPGAP until September 30, okay? Not until your H-1B is approved, until September 30, so you want to pay attention to that. Okay, so the H-1B procedure. The first step will be for your employer to file a labor condition application, LCA, not to be confused with a labor certification, which is the green card process, which is also with the Department of Labor, because the government is confusing. But with the LCA, this is where your employer verifies that they are going to meet certain wage requirements. They will say that this is what the prevailing wage, so remember that's the industry wage, is for the area, and this is what we pay, and so we meet the wage requirements. That takes about a week, and then, I'm sorry, I did have a cold about a week ago, so I apologize for the coughing. And then Department of Labor will then issue a certified LCA, at which point your employer is able to file an I-129, and that is your H-1B petition. And they file that with USCIS. In that I-129, they are going to say that the job is a specialty job. They're going to say that you have the requisite education. They're going to include the LCA to show that they're going to pay the right wage. And if you have a license, they're going to include the license. They'll ship that off to USCIS, and there's two ways that they can do it. They can, they can do it through what's called a change of status, which is where they say, you are in at status, and USCIS, please change their status automatically to H-1B. And if they do that, that's where CAPGAP comes into play. The other way that they can do it is say, please just say that this person is eligible. And if they do that, then you have to take that approval notice that you get and go to a consulate outside the United States in order to come back in H-1B. And there's reasons why you might do that. One of them might be you have a lot of OPT time left. And if you have a lot of OPT time left, you may not want to use that all up, particularly if you're, say, from India and you're facing long backlogs. You might want to use all of your OPT time first, then enter H-1B, so that you have more of that time, lead time, in order to get to your green card, right? Because remember, you have to file for your green card by your 5th year of H-1B. So if you're not sure whether your employer is going to sponsor you for a green card, you might want to use all your OPT time up first. This process may change this year. There's something called pre-registration that may be coming. And basically what that would do, excuse me, is push up the lottery, right? So the way the lottery works is once everybody's filed those I-129s, that's when they run the lottery. So they're doing the lottery right here. And for those that are listening to the recording, I'm pointing to the USCIS orange arrow. So if you are doing the I-129, that's pretty late in the process, right? What USCIS wants to do is before, I apologize, any of these arrows takes place, so before this yellow DOL arrow, they want everybody to enter the information to say, we're going to hire, this is who we are as an employer, this is who we want to hire, this is their passport number. They are going to, we're going to apply for them, we're going to petition for them rather, in order to get an H-1B. At that point, the information will already be in the computer, then the computer will run the system, and then it will invite the company to petition for the H-1B. They say it may happen this year. We don't know. Government databases, unfortunately, tend to not roll out very well, and so we're a little bit nervous about them just rushing into this a little bit, but we'll see how it goes, right? It could actually be a good thing, because it may mean for your employer it's not as much of a financial burden to try, because if you think about this, you know, the filing fees your employer gets back, but the legal fees, they won't, because the lawyer, the attorney has already done the work, right? And they have to pay for the work that's been done. So if you go through the lottery, there's a lot of prep work and everything that has to go through. And so they're putting that money on the line, so to speak, and they may or may not even get approved. So just to sum up the H-1B here, can you work? Sure. You can work in 3-year intervals up to 6 years unless you start your green card by the 5th year. Who can you work for? Well, you can work for the employer listed on your approval notice called the I-797. That's the approval notice. And you can perform the duties that are specifically listed in the H-1B. There is some room for promotion, but you want to make sure that your employer checks with your attorney before they do so. You have to have an employee-employer relationship, and there is some flexibility of changing jobs where that as soon as the new employer files the H-1B petition, you're allowed to start work for the new employer. I generally, if you're my client, I don't generally recommend to my clients rather that they do the portability, because I want them to be secure with that H-1B approval notice before they change jobs, just because if it's not approved, right, it used to be we're fairly confident about approvals in most cases. If it's not approved and you've given notice to your employer, that puts you in the lurch, right? So I generally recommend to foreign nationals, if I'm advising the foreign national, wait for the approval before switching jobs. And can your spouse work? Well, not until there's been progress towards your permanent residence. There are other visa types. So the L1, go ahead.
So how about traveling during the H-1B?
So it depends.
Limited time for traveling outside the country?
So you're talking about while the H-1B petition is pending? So it depends, right? So if you are in F1 status and you are changing status to H-1B, you cannot travel while the change of status petition is pending. If your employer asks for consular processing, that's where you go outside the United States and get the visa and come back in. There's no problem with traveling as long as you have an I-20 that allows you to travel, you have a valid passport, and you have a valid visa stamp, right? After your H-1B is approved, there is some leeway of traveling if you're doing the change of status before October 1 when your status would go into effect, but that's more case by case and you want to check with whoever's handling your H-1B work before you can travel. If you're already in H-1B status and you're going to extend, there's no harm in traveling. As long as, again, you have a valid passport, you have a valid I-797, and you have a valid visa stamp.
Thank you.
Yeah. So with the L1, this is the intercompany transfer. This is when, say, Kodak wants to transfer somebody from Kodak UK to Kodak US. Or it's when an entrepreneur outside the United States has a company outside the United States and wants to transfer themselves to their new branch or subsidiary or whatever it is in the United States. And the requirements for this are basically that the person, the foreign national, has been for 1 year within the last 3 years in an executive, managerial, or specialized knowledge position for a full year, not including any time while they were in the United States, within the last 3 years. So what that means as an executive, these are very 1960s definitions. So executive means they are at the top of the company, they're only setting policies, they're not doing any of the work, they're not making any of the widgets, they're just overseeing, they're just setting goals. Think Mad Men, that's basically what the government thinks when they think of an executive. Likewise with a manager, same thing. They expect that you have subordinates, that there's a clear hierarchy. This isn't really how companies work anymore, right? Companies are more bands, but they expect to see a pyramid where you are overseeing managers or you are overseeing professionals, right? And they're very strict about that. So that's what a manager is. Or you have to have specialized knowledge. Specialized knowledge is not something that you would learn here at RIT. It's not something you would learn from me at a professional conference. It's something that is specific to your company, right? It's either special knowledge or advanced knowledge where you have something that's unique to what you do, right? It's sort of like intellectual property. It doesn't have to be intellectual property, but it's akin to that, right? Some procedures, some protocols, some infrastructure, something that's unique to your job that you need to do in that job. And so you have to have one of those three things for 1 year within the last 3 years. And then you have to be transferred to an entity that is either a branch of the same company or has an equity relationship, a majority equity relationship, so that's to say 50% or more generally, where it has the same owner and controller of that company, right? So if it's that some other company is a 75% owner of this company and your company is 25% owner of this company, that's not going to work. It has to have the same owner and same controller of the company, okay? Compensation is flexible. Where you can work for, it depends on the type of L, but generally it's for the employer that petitioned for you. There is more flexibility with changing jobs as long as you stay within the same category. So if you've got an L to be an executive, as long as you stay an executive, you should be okay. If you're going to be a manager, again, as long as you're some type of manager, you're okay. And if you're an L1B, again, as long as you're in some kind of specialized knowledge position, you're okay. And your spouse can work after applying for a work authorization document. So sometimes what foreign nationals will do, if they're entrepreneurial minded and they can't seem to figure out a status that works for them to start their company in the US, they'll start their company at home and then create a branch in the United States. The nice thing about that is we'll talk about in a little bit, there's a green card path that is facilitated by going through the L1 system, okay? So that's what the L1 is for. E3, we don't have any Australians, right? No Australians have come in since. Basically, they got their own status because they helped in the Iraq War. So they have their own carve-out. And then we have no Canadians or Mexicans. Okay, they've got their own status because they're parties to NAFTA, or no, I think it's USMCA is the new acronym. So again, since there's no one in here, we're not going to sort of twist the knife and give a special status that you don't get. So how many people have Nobel Prizes or Academy Awards? Any Emmys? That's well, there you go. So if you've got one of these big prizes, right? For some reason, Tony isn't listed. I don't know what they have against Broadway, but I think you can make a fairly good argument. If you have one of these great prizes, you could potentially get an 01. If you don't have one of these prizes, you could still potentially get an 01. You just have to show that you have 3 of 10 criteria of lesser renown, right? And this is generally good for if you have a PhD and you have lots of publications. An 01 might work for you. If you don't have a PhD, probably not the best option for you. But if you do have an Academy Award and you're going to work in that field, then this could potentially be an option. Yeah, go ahead.
Is there a lottery for the 01?
No. Nope, there's not. So that's the good thing about O's and L's and TN's and E's. There's no lottery.
Can we set application like instead of a company?
Say again?
Set application like by yourself. Like you have a PhD and you apply by yourself to the 01.
So you can't be self-employed, but you could have an agent. And so there's 2 different ways of doing the O. One is that you have an employer, and one is that you have an agent. The agent would be setting up jobs for you. You think of like a theater agent or an actor's agent or something like that, right? The agent is setting up jobs for the actor. But generally, if you're not in a performing art, you're going to be looking more at an employer hiring you. So if you do have your own company, you want to show an employee-employer relationship, okay? L's, there's a little bit more flexibility where you can employ yourself. E-visas. E-visas are for specific countries. If your country has a treaty with the United States, again, China and India, for whatever reason, we don't have treaties with those countries. But if you are able to do significant trade with the United States and your company and your home country, you could do an E1. If you are going to do significant, or if you have a significant investment, which is to say $100,000 or more into a new company, you could potentially do an E2. These are the options for entrepreneurs potentially. Nice thing about E2s is that spouses can work, and there is some flexibility. You get to apply at the consulate, which is always nice because consulates tend to be a little bit more fair in their adjudications generally. So this can be a great option. Some other things just to think about with non-immigrant status. If you are from one of the travel ban countries, you want to pay particularly close attention to what the travel ban allows you to do and what it does not allow you to do. So if you're from Iran, for example, you can get student visas, but once you get to the professional visas, that becomes much more challenging, so you may not be able to travel for a while, right? You may have to stay in the United States. The other thing to keep in mind is that at the consulates, there are visa issuance delays called administrative processing. We've seen an uptick in this. If you get into administrative processing, it could be a whole host of reasons. It could be that the adjudicator doesn't know the visa type as well and needs to get approval. It could be that there was a flag on your file. Perhaps there was some question about some work that you did at some point. Or there could be that your name matches the name of somebody that has engaged in activities that the United States government has found controversial. Or it could be just a fluke where your file ends up on somebody's desk and doesn't get finalized, right? If you end up in administrative processing, generally the best thing that you can do is try to email them and keep up with them, but there's no real recourse because there's no appeal of what the consulate does, right? So you can't sue the consulate for denying your visa. So this gets very frustrating, and we've seen an uptick in administrative processing. Another thing to keep in mind, as we've mentioned a few times, consult with your international student advisors before you do anything. Do not sell it up on the App Store until you talk to the great team here, because it could be considered work. And then lastly, with respect to non-immigrant status, we talked actually about this because of the question here. You want to be careful about travel once those H-1Bs go into place. You always want to be careful about travel, especially if you have anything pending. Always make sure you know. And that's sort of the moral of non-immigrant status, is that you need to watch out for yourself, right? You need to make sure that you can't count on your employer always to understand the rules, right? Even sophisticated employers can sometimes not know the rules because they're very convoluted. So if they say, hey, we need to transfer you to Poughkeepsie, you need to make sure that and you're on an H-1B that allows you to work in Newark, you want to make sure that they have first gotten authorization from the government to do that transfer. So once you get onto H-1B status, or even while you're on OPT or whatever status you are, if there's ever going to be a change to what you're doing, so for example, if you're on OPT and they say, oh, we want you to work in our Beijing office for a little bit, that could count towards your unemployment and get you into some trouble. So you want to always check and say, okay, well, before we make this change to my job, let's check with Immigration Counsel, let's check with RIT and make sure that this is okay for me to do on my status before we go ahead and do it, because it could cause me to lose my status and lose my job. So just always be paying attention. That's really the moral of the story. Yeah, go ahead.
So I'm originally from Syria, but I have another passport. Would that be an issue for the OPT or for the H-1B?
Generally, having dual citizenship gets around the travel ban. That's historically, up to this point, that's been the case. But if you have any questions about OPT or J's, I would meet with ISS. They'll be the ultimate authorities on that. Although it is funny, sometimes students will say, oh, my international student advisor told me X, but I don't really think that's the case. Can you explain to them why I'm right and they're wrong? And I said, well, I would trust them over basically anybody. So what they tell you, you can trust them. So long-term residence, there are 3 primary paths. There are other paths for green card, but these are the ones that you may come into contact with. Family-based, you are related to a U.S. citizen or a permanent resident. You can get a green card through that path. Diversity lottery, you may have heard about this, where if you come from countries that don't send a lot of immigrants to the United States, in the interest of promoting diversity to the United States, we allow people to throw their names into a proverbial hat, and every year we give out green cards that way. And then the last way, the way most of you will probably know about this, is through the employment-based path. That's where what you do makes a difference to how you get a green card. So we're going to talk about each of these paths very quickly here. So family-based. These are the different types of family-based categories. So basically, U.S. citizens can sponsor the most types of people. U.S. citizens can sponsor their spouses, their children, and their parents, right, and their siblings. Depending on which one of those categories you fall into will tell you how quickly they can do. If you are a spouse, minor child, or parent of a U.S. citizen, and that's parent whose U.S. citizen child is over the age of 21, then you can very quickly get a green card through what's called the immediate relative program. So yes, if you do get married to a U.S. citizen, you can get a green card that way. That said, do not get married for a green card. That is a federal crime, okay? And again, committing crime is bad, right? So we can all agree on that. So do not get married for a green card. Now, there's nothing wrong with only dating U.S. citizens. I don't know that necessarily makes sense, but you're allowed to fall in love with a U.S. citizen, and certainly if you do get married to a U.S. citizen, get the green card, right? By all means, get the green card, right? Some people get so upset about it because they want to say that they earned a green card on their own. Don't buy into that garbage. Just get the green card, okay? But don't get married for the green card, okay? That's a federal crime. If you happen to fall in love with a U.S. citizen, if it's a legitimate marriage, even if it's not for love, I would recommend getting married for love, but I'm not going to judge, right? But as long as it's a legitimate marriage, you can get a green card through that way. Again, do not get married for a green card. But again, they can sponsor all these other categories. Their siblings being the longest time. I'm going to show you how that in a minute. If you are a lawful permanent resident or even a conditional permanent resident, so if you're a permanent resident green card holder, you can sponsor your spouse and minor children. You can also sponsor your sons or daughters over the age of 21, but once they get married, you can't sponsor them anymore. You also can't sponsor your siblings, and you can't sponsor your parents. So permanent residents are more limited in who they can sponsor. So we talked about backlogs a little bit. This is what we're talking about when we're talking about backlogs. So this is the visa bulletin this is the visa bulletin for October. Every month, Department of State puts out the availability of green cards, right? So there's only a certain number of each type of green card put out every single year, right? And it goes by fiscal year. There are categories that are carved out of these limitations. So remember we talked about only 7% can go to each nationality. That's why you see different nationalities carved out here, because if they're specifically delineated on this chart, that means in some category they've used more than 7%, okay? And these are the different preferences, and each preference category is given a certain amount. So you want to think about this chart as sort of the deli counter at Wegmans, okay? So when it comes to, and you've all been to a deli counter, I presume, at this point. So basically what you do is you go up to the little turnstile, you pull that little ticket, it's usually a little red ticket dispenser, it could be another color, any color's fine. But you pull the little dispenser and get a ticket, you say, you're number 62, you're number 28. And then you wait for that neon sign to say, now serving number 28, right? And then you're number 28, you get to go up to the counter. Immigration works exactly the same way. It's just that when you go to the counter, when you file that first petition, you pull your ticket, and the ticket, instead of saying you're number 28, you're number 62, it says the date that you pulled it. So when you're an when you're a family-based green card, you're filing an I-130. That's the immigrant petition that's pulling the ticket for you. The day that you pull that ticket, so let's say you did it on January 7th, 2015, you pull that ticket and it says January 7th, 2015, okay? And then you wait for the big neon sign, that's our chart over here, in your category, to say the date that is on your ticket or earlier, okay? So for example, if you are a sibling of a US citizen, F4, from the Philippines, the Department of State is now serving people that pulled that ticket July 8th of 1998 or earlier, okay? So that's a long time, that's 21 years, okay? And it may not actually even be 21 years, it could be longer, because it really sort of depends on how many petitions were filed between now and that date, right? Because if you think about it, this isn't going to move forward. The only way this would move forward the same amount every single month is if every single month the same number of people sent in their petitions, right? But we can't be, we're not that organized as human beings, right? We don't line up to line up, okay? I hope not. So there could be a great number of different types of petitions, or different number of petitions in there. And what that basically means is sometimes this will move forward very quickly, and sometimes it might even move backwards and towards, say, the end of the fiscal year, when visas are running out, they need to slow down the number of green cards they're issuing. They could actually move backwards to slow people down from applying for green cards. If you see these C's, that means everybody in that category can immediately apply for a green card. So for the F2A, that's spouses of permanent residents. The reason that that's current is they're trying to flush those out of the system. They have a lot of unused green cards that they've been current for a little while. And those will eventually retrogress as well. Again, spouses, parents of U.S. citizens that are over the age of 21, and minor children of U.S. citizens are not on this chart because they are always able. They're always able to walk right up and get the roast beef that they want, right? So that they're not on this chart. But everybody else in the family-based categories fall into this category. So again, if you're going to be applying based on your sibling, it will be a very, very long wait. Yeah, go ahead.
Can you specify what those F mean? Those F categories, exactly what do they mean?
Well, so F1, I'd have to look them all up, but basically these are the categories that you see over here, right? So we have sons and daughters over the age of 21. We have married sons and daughters. we have siblings, and then we have F2A, which is the spouses and children of citizens or of permanent residents. So that's where that kind of goes.
I have a question.
Yeah.
For example, your uncle who is a U.S. citizenship or someone who you are related to, but is not your parent or a sibling, write a petition for you.
Your uncle cannot.
I'm just giving an example. Someone who is related to you, but is not your parent or your sibling.
Right. So only parents or siblings are able to sponsor for you or children. Yeah.
What's the waiting time for the ones divorced with children?
Say again?
The ones divorced with children.
Divorced with children? So you have to be married to a U.S. citizen, or you have to be the parent of a U.S. citizen. So if you're divorced, you're not married, so they can't sponsor you, unless it's the child that's the U.S. citizen, then potentially they can sponsor you.
No, I mean the waiting time if your dad is making a petition for you. If your dad is U.S. citizen and he's making a petition for you and you are divorced with children, what's the waiting time?
Oh, so you're no longer married?
Yeah.
That's a good question. I would have to look that one up. I've never come across that situation where the person was married but then is no longer married. I don't know which of those two categories you would end up in. My guess is you may end up in sons and daughters over the age of 21. Not that it's you, but the person may. Yeah.
What is the difference between the top wait time and this bottom line? For example, in this house.
So this is a weird chart, just to be honest. But basically, the axes don't make a whole lot of sense here. But the way it works is that this is the type of person that could be sponsored for these four right here. And then this is, the sponsor, and then this is the wait. So these two kind of go together, and these two kind of go together. And then this last one is just exception. So it's not a well-designed chart. I didn't design this myself, but basically the information it's trying to get across is that if you are a U.S. citizen and you're sponsoring a sibling, the wait could be up to 13 years. Okay. If you are a lawful permanent resident or a conditional permanent resident and you're sponsoring a sibling, well, you can't. That's why there's a note there.
So this wait time is just start the process. Because for example, the spouse is going to take 2 years, let's say.
Well, not to start the process. It's how long you have to wait until you can finish the process, go up and get the green card. So remember, you file the I-130, that's you're pulling the ticket, and then you wait for your number to show up, and then you can go up and actually get the green card.
Okay.
It's a multi-step process, right? So the first process is filing the immigrant petition saying, I would like to get a green card, I'm eligible. And then after you've demonstrated eligibility, you have to wait for USCIS to say, okay, or Department of State rather, to say, okay, now you can actually go request the green card. You've already shown your eligibility, you got your place in line, now you can actually go get the green card.
Right. So then you have the process.
What's that?
So you have the process starting, let's say the spouse, they have to wait for the entire process. It starts immediately.
So you start as quickly as you can, get your place in line, and eventually you can finish the process.
Right.
That's basically how it works. And that's why you want to keep your non-immigrant. So if you're in H-1B status, right, that's why you want to be in H-1B status, you can continue to extend that H-1B while you wait. So diversity lottery. This is just what it is. So if you are eligible, if you come from a country that doesn't send a lot of immigrants to the United States, you can apply for the diversity lottery, and I think it may still be open. I'm not 100% sure if it was closed. Well, there you go. And historically, Fs and Js have not had any great intent issues if they want to throw their hat in the ring. So there really isn't any harm that I know of if you qualify, which all of you qualify because you all have high school diplomas, from giving it a shot. And people win every year, right?
We have our winners at RIT.
Yeah, so you might as well give it a shot if you're eligible. You go ahead.
So let's say you're in J1 and you have a two years rule applying, and then you select it from diversity lottery.
You'll still have to deal with the 2-year foreign residency requirement, very likely. So you can get a waiver potentially. If you have Fulbright, though, it's very hard to get that waiver. So employment-based, this is the primary method that most people will get their green cards. So EB1, EB2, EB3, EB4, EB5, probably some of you may have heard these terms before. The one thing I will say, just as I said with the marriage-based green card, if your employer is willing to get you an EB1 green card and you can actually get it quickly, there's no difference than if you get an EB2, EB3, or EB4, right? Just take the green card, whatever type of green card it is. There's no special party that you get to go to if you're an EB1 green card holder as opposed to an EB2 or EB3 green card holder. There's no special prize or medal that comes along with it. A green card is a green card is a green card. So again, if you're planning to stay long-term in the United States, if your employer is willing to get you a green card and it makes sense from a timing perspective to go in one of these categories, just go with it and support them in doing it, because it can sometimes be hard to find somebody that's willing to sponsor you. With these green cards, so these are the preference categories. So employment-based 1, employment-based 2, employment-based 3, and so on. Employment-based 1, these are for people that we think are going to create jobs in the United States. So these are people that have extraordinary ability. This is like the O1. If you are somebody of extraordinary ability in your field, you could potentially get an EB1A, extraordinary ability green card. And the nice thing about the EB1A is you can self-sponsor. So if you're very successful, if you have a lot of publications and sorts of things, and you want to turn that into an entrepreneurial company, EB1 could potentially work if you've already demonstrated a track record of being very successful. It's the hardest probably of the discretionary green cards to get, but people do get it. And if you can get it, then it's in the top preference category. And the nice thing is it is not employer specific, so you can take it with you if you were to change jobs. Yeah.
How is the threshold set when you say you're very good in your profession? How is the threshold usually set? Do they compare?
Well, some do. It's not a clear one. So I've seen people with weaker classifications get approved on EB1A, and I've seen people with very strong, so lots of Nature articles get denied. It's very, very subjective. And the thing with USCIS is that the adjudicators, there's no education requirement per se with the requirements. So you could have somebody that has an associate's degree, not that there's anything wrong with having an associate's degree, or you could have somebody that has a law degree being the one adjudicating the case, with all of the different experiences and worldview that they have. And so what that means is that educations are inconsistent. So it's not that there's a clear, you will absolutely get it if you do X, Y, and Z. But there are certain minimum criteria that you have to have. You have to show that you meet, that there's a list of about 10 criteria. So there's things like publications, it's having media articles about you, it's having judged the work of others, it's having earned prizes, it's having a high salary, or having a prestigious membership, or a senior level in a distinguished entity. If you can show that you meet 3 of those, and that you meet 3 of those in a distinguished way, so it's not just to meet the minimum criteria, it's to meet the criteria, but then also do so in an extraordinary way, that's how you get the green card. And because it's so subjective, USCIS tends to be very inconsistent in its adjudications. But basically, this is again something that you want to have, a lot of publications. It's generally more well suited for PhDs than everybody else. Although if you do have an Academy Award or an Emmy or whatever it is, you could potentially, or a Nobel Prize, you could get one of these as well. So, yeah. Similar to the EB1A, but not quite as hard, is the EB1B for outstanding researchers. If you're going to be an academic, your employer could potentially, your university employer could sponsor you for an EB1B. Also, if you're going to work for a private institution, that could be a for-profit company that does research, you could get an EB1B, which is for outstanding professors and researchers. It's similar to the EB1A, but I just listed all those criteria. You only have to do 2 of very similar criteria as opposed to 3 criteria. So this can be a great option for you if that is something that applies to you as a researcher or a professor. I mentioned that if you're in an L1 status, that there is a green card that is very similar to the L1. That's our multinational managers over here. So if you were an executive or manager outside the United States for 1 year within the last 3 years, and you're going to be transferred into a managerial or an executive position, you could potentially get an EB1 through EB1C, which is an international or multinational managers or executives. So those are the EB1 top preference categories. EB2, this is for people that have a master's degree or higher, a bachelor's degree plus 5 years of experience, or who have something called exceptional ability. If you meet one of those criteria, you can get an EB2 preference category. There's 2 ways of doing that. One is through what's called a national interest waiver, which is that you are doing something that is so important to the United States that it's in the national interest that we are going to waive something called the labor certification. Okay? So what is in the interest of the United States? It's very broad. It could be that you are working on a particular variation of soybean that's very important to the agriculture of the United States. It could also be that you have a particular skill in a very unique form of dance that comes from an area that hasn't had as much world exposure, and so you're helping the cultural needs of the United States as well, right? So what's in the national interest can vary quite extensively, but you also have to be well positioned. So this is again showing some of the similar things to the EB-1A, where you've had publications, that you have prestigious degrees, that you have, you've done things with your life, that you have accomplishments, so you are well suited to advance that national need. If you don't fit into that, you can do the labor certification. The labor certification is where your employer goes out and tests the labor market. So you have the job, but they go out and they test to see whether there's any U.S. worker available. If you're going to be an academic, the university gets to see if you are the best available, right? So there's a difference there. For most employers, it's, is there any available U.S. worker that's minimally qualified for your job? If there is, the labor certification can move forward. If you're an academic teaching in a university, then because we want the best of the best teaching our kids in universities, if you are the best qualified applicant, you get the job, right? And that survives the labor certification. And so how it works is that they go out and do the test of the labor market, they do that recruitment, and assuming that they can't find anybody, and often if you take jobs in places like upstate New York or Rochester, they can't find anybody. A little plug for staying upstate. If you can't find anybody, then your employer will go to the Department of Labor and say, hey, we did this test of the labor market, please certify that there is an opening for this position. They will certify that labor certification, and then the employer can then file the I-140, which is the immigrant petition to say, okay, we did this test of the labor market, and we have this great RIT grad, she's amazing, she meets all the requirements for this job that we were seeking for. Please say she's eligible for a green card. That's the I-140. And then once their visa category becomes current, so that visa bulletin, that Delhi County chart we were talking about, once that happens, you are then able to file the last step, which is the I-45, which is to request the actual green card. If you're EB-3, all EB-3 is labor certification, so there's no national interest labor in the EB-3 category. So that EB-3 works the same way with the labor certification, testing the labor market. Can't find anybody, the government says, okay, you have this great person, you can therefore continue. EB-4, I'm assuming there's no religious workers, nobody wants to be a monk. It's okay if you do. There's a green card specifically for you if you do. And then EB-5, this is where you invest $500,000 or $1 million, and those numbers are going to go up to $900,000 or $1.8 million. In the United States, it's either a regional center, which is something that pools projects, or directly into a company that is either failing or is a new company. And that investment is connected to the creation of 10 jobs. So it's actually a job creation visa. The way that people normally do this is that they'll find that over time, they've invested in some property, they have a house that has greatly appreciated in value, right? They're going to move. This happened in Shanghai. This happened in, say, San Francisco, right, where home values skyrocketed. Then they take a mortgage on that property to get the value out of that property, and then they can either give it to a child that they want to have a future in the United States, or they themselves can invest. So that's generally how that works. Yeah.
Can you give us a quick overview for the Panama Canal employees?
Say again?
A quick overview for the Panama Canal employees.
Panama Canal employees?
Yes.
I've never done one, to be honest,
Oh,
so
okay.
I can't give you an explanation of that. But assuming you would need to very likely have worked on the Panama Canal.
I'm from Panama, and that's one of the options we're considering.
Okay.
In case I need to go back. But
I'm
first
assuming-
time I've seen this. So.
Yeah. So I'm assuming that that's a very specific. So you probably want there's probably one or two immigration attorneys that have done those.
Something like that.
Yeah, because it's extremely nuanced. So, but in full disclosure, I've never done a Panama Canal employee. The other unique thing about immigration is you'll find that there's all these very discrete things in the law. So the very first, or it's either the first or second question on the labor certification application asks whether the job is as a sheep herder, right?
which is just bizarre. I mean, I think it's the dream of most immigration lawyers to achieve labor certification at some point because you have to answer the question every single time. And invariably the answer is no. And the reason is actually because there are sheep herders that are part of indigenous cultures that have historically been able to, graze lands that span both the United States and Canada. And so there's special treaties that govern a specific industry, right? And so that's what you end up finding is that there are particular categories that are very, very unique that you will never touch in your career, right? But if it ends up working out for you, that would be fantastic. But again, these are all very, the primary methods that most of you will be looking at are through either the labor certification or through either national interest waiver or extraordinary ability or senior researcher or multinational manager. Yeah.
So if someone is eligible for EB4, and at the same time he is on J1, that the 2-year rule applies on him.
Yeah. The only exception to the 2-year foreign residency requirement generally is if you're going to be an asylee or a refugee, which is an allowance chart.
I'm eligible for EB4, but I have not filed my documents because I'm on J1 that I am required to be back in my home country for 2 years.
Well, so I can't give you specific advice about your case. So what I would say is that before you make any decisions, you would want to speak with an immigration lawyer, particularly one that's expert in the type of green card that you're thinking of pursuing. Yeah.
Would it be better to apply for a general or a regular or most common type of visa or visa-specific ones?
It depends on your case.
Oh, okay.
So there's no harm with trying to get multiple types of eligibility. Yeah.
Okay.
Yeah.
I have 2 questions. The first one is how long you can have a EB1 or EB2, and the second is can you switch job for those when you have those visas?
So you're saying can you have both EB1 and EB2?
No. Let's say EB2. So how long can you have your own EB2 for how long? Is there a specific time, 5 years, 10 years?
So you got to think of these differently than non-immigrant visas, right? So these are pathways to getting a green card.
I see.
These are not visa statuses. So if you are in an H-1B, right, the H-1B is good for 3 years up to 6 years. The O1 is good for 3 years, and then you can extend in 1-year increments. L1 is good for 3 years, and then you can extend twice for up to 7 years. For EB1, EB2, EB3, these are pathways to get to permanent residence. So once you are through that process, I'm going to have a chart to show you how the process works. Once you get to that green card, you're a green card holder, right? There are variations, right? There's something called conditional permanent residence. So if you get a green card through marriage and you've been married for less than 2 years, you'll get a conditional permanent resident card. Or if you go through the EB5 program, initially you'll get a conditional permanent resident card, which means that you'll have only 2 years initially on your green card, and then you have to show that you meet some criteria after the fact. That's usually what a conditional permanent resident card is okay, you've shown eligibility, but now we have to make sure that you really have met the eligibility afterwards. So if you've been married for less than 2 years, they want to check in with you after 2 years to make sure, was this a legitimate marriage, right? If you're in EB5, you've made the investment, but let's check in to make sure that you've actually created the 10 jobs before we get you the full green card. If you get the full 10-year green card, which most of these categories are going to give you, you're a permanent resident, right? Even if your green card expires, you're still a permanent resident. It's like getting a passport extension. You're still a citizen of your country. Your passport just might have expired, right? So you should get that green card extended because you want to have proof of your permanent residence. But you're a permanent resident at that point. You can live and work anywhere in the United States. So once you've gone through this process, and these preference categories are means to an end, they're pathways that you walk down to get to that green card. Once you get to that green card, you're a permanent resident. You're all set for the rest of your life, unless you give up your permanent residence.
Okay, one more question. What about your spouse, your wife or the husband?
Yeah.
They will get this.
They can be dependents of you. Yep. Yep, they come right along with you. Unless you get married to them after the fact, and then you might have to sponsor, we're showing spouses with permanent residence. Yeah.
I have a particular question. So if somebody came in F1 status and got married and filed a green card in F2A like a spouse of a permanent resident. And the visa is expiring soon, maybe in December. So
Visa as in your I-20 is expiring, or your visa stamp that allows you to travel?
on the passport.
Okay.
No, not on the passport, only the F4 I-20. So does he need to maintain his status after I-485 is accepted by the USCIS?
It's going to depend. So if you have a valid I-485 that's pending, then you could potentially stay in the United States while it's pending. With a green card, you're typically filing what's called advanced parole and an I-131 for work authorization at the same time. So this person would need to make sure that they're maintaining that as well. If you can maintain your underlying non-immigrant status, you want to maintain your non-immigrant status. Generally, if you're in F status and you've applied for a green card, you cannot travel. And the reason for that is when you come to the United States border, you have to be eligible for the status that you have. And the F status requires that you have what's called non-immigrant intent, which means the intent to not stay in the United States. So if you have a green card pending, right, if you have a green card application pending, that's showing intent to want to live here. And so if you were to come to the border and show your visa, say, I want to come in, they would say, I'm sorry, you're not eligible, you don't have the requisite intent to re-enter the U.S. So if you're going to be applying for a green card directly from your F status, it may mean that you're staying in the United States until you get that advanced parole, that travel authorization pending. And so this is all very specific stuff, right? So if you're not following what I'm saying, don't worry. This is stuff that you would work out with your attorney when you go to them and say, hey, I've got this problem here. How do we work this out? How do we get this so that I can travel? Again, this is that self-advocacy I was talking about before, where you want to make sure that you're checking before you travel, right? Or checking before you file a green card petition, because there could be implications to your ability to keep up in your studies. Generally, there's not as much of a problem. I've seen schools still be able to issue I-20s even if you have a green card pending. I don't know if that's, yeah, so it's, Sue's saying no, so.
That's my particular case. So,
yeah.
So I already filed my green card, so it is pending, and my F1 is I-20 expiring in December. So I don't know whether I have to apply for OPT or I can just stay in a pending status.
Well, so I would suggest that you talk about a consultation where you talk about the specifics of your case. But you may or may not be able to get OPT because of the green card, but there's other ways to get EADs based on the fact
I
that
already
you're.
filed that too.
Yeah, so there could be different ways of you getting work authorization. So again, because it's more specific to your case, you would need to set up a consultation where you can see all the documents and check it out. Because, and just as a general, the reason I have to do these caveats and say that you need to have a consultation rather than saying this is exactly what would work for you, is that there can be little nuances to your case that changes everything. And so I would hate to give you general advice based on 2 seconds of talking that you rely on to your detriment, right? So with everything that's said here, even if you ask me a question about your case specifically, take it with a grain of salt. Take it as an impetus to look into it more or potentially set up a consultation later, and not as that's the final word and that's absolutely what I should do, because immigration is very convoluted, very complicated, and so you want to make sure that somebody's looking at all of your documents and vetting every question, and that you are getting the support that you need. So these are the primary ways. This is the visa bulletin. So this is our deli counter employment-based categories. As you can see, so this is actually they've issued a new one that's even a little bit different from this one. But you see all these C's. You can ignore these U's. The reason that there's U's is that the government can't pass the budget. Basically, there's some categories that need to get annual congressional authorization. And so every time there's a threat of a shutdown, the Department of State will put a U saying that this visa is unavailable because they haven't yet gotten congressional authorization to continue it. They have since gotten congressional authorization, so those are available again. But again, you see these dates. If you're from India and you're going to be in EB3, you're looking at January 1st of 2009, right? Some estimates say it's a 20-year wait. Some say that there's one estimate out there that says it's a 150-year wait, right? I hope that's overblown, but
it's what's being said out there. So if you're from India, if you're from India rather, you're going to really want to focus on getting to an EB1 or EB1 standard because it's a much shorter backlog, right? Whereas if you're from everywhere except for India and China, the EB2 category is just fine, right? You see this C, that means anybody, right? So an NIW, which is a lower standard, it's an interesting thing, right? So everybody in the past has always sought after EB1, and actually right now, EB2 is way better. It's a lot better for you, right? So again, the goal is to get to the green card, and you want to pay attention to this chart. It gets put out every single month. The November chart actually just came out, so these numbers are actually these will no longer be valid as of October 31. There's a new chart out there, and all you have to do is search Visa Bulletin on the Department of State, and you can see what this chart is. We talked about the labor certification, how that works, but I want to get to this slide here, because the way that this works is that the first step that you do, that's pulling the ticket of the deli counter. So if you do the labor certification, for whatever reason, the computer system that you do the labor certification in is called PERM. It doesn't mean that you have to get any particular hairstyle. It just is what they call the system, right? So once you file that first step, you get, that's you pulling the ticket. So that's filing the labor certification. Now, not every category requires a labor certification. So you will immediately file the I-140, or if it's an EB5, it's an I-526, or if it's EB4, it's an I-360, I believe. And so you go down this path, and if you are not current, if you don't have a C, or if you don't have a priority date that is prior to the date that's listed for your category, you stop right here. This is where you wait. If you remember that first chart, you saw that big yellow pause sign saying that you had to wait for your backlog to leap up. This is where you're pausing. This is the wait. Once your priority date becomes current, you can then either file for an adjustment of status via Form I-485, or you can consular process, which means that you're filing outside the United States, right? This is really the primary method. There are some ways of self-petitioning which shows immigrant intent. This is where you're really showing immigrant intent, okay? So if you're on a student visa, you want to be very, very careful about filing an I-485 until you've talked to ISS or you have talked to an immigration attorney. Well, and hopefully you are talking to an immigration attorney to do this. And that's not an advertisement, that's just, you can talk to whatever immigration attorney that you like. And then, so again, no PERM required, no labor certification required. We talked about this in detail, EB1 versus EB2. There are backlogs in both, unfortunately, for India and China. EB2 is not backlogged for everywhere else. EB5 investors, we talked about this as well. There are increasing backlogs in EB5, but if you have access to funds in excess of $500,000 or $1 million, really at this point, because of the time constraints with the new regulations coming into effect on November 21, it's more likely going to be $900,000 than $1.8 million. If you do have those assets available to you, which some people do, I wish I did, but some people have them, then you could potentially get a green card through creating 10 jobs. So planning ahead. There are government resources out there that you can pay attention to. The Department of State has a really great website. I really actually like the simplicity of the Department of State website. USCIS, their website goes through a lot of changes and can be somewhat convoluted, but they do have a fairly good system now. They're working on it to try to get more information and have the things that you need right up front. They usually have good checklists around the H-1B time period saying, what you need to include. So you can find their resources there. We have additional resources. So we recently started a podcast. Actually, Jeff Cox was just on it. So if you want to go listen to that, it's really great. You can hear about his really interesting past of I think he was in the Peace Corps and his parents were in all sorts of different things. So he's lived all over the world. We have free webinars all the time. So if you go to millermayer.com/webinars, you can listen to our whole library of webinars. So we have things in entrepreneurship, how to get a green card, alternatives to the H-1B. If you're a physician interested in the medical community, there's ones about doctors. We have all sorts of different stuff out there, and it's free to listen to. You do want to be careful about social media. So I don't know if you have how recently you filled out a DS-160, which was the petition that you would have put in to get your visa stamp to come into the U.S. They do ask for your social media now. right? They ask for your handles, they ask for your usernames, because they want to look you up, right? There was the story of the kid from Harvard who came to the border and was stopped because they looked up his Facebook and said they didn't like who his friends were, right? There was a big outcry, right? There should have been. But that's the type of thing that you want to be careful of, right? When right after the election, there was the Women's March, and there were some people that were very vocal about their politics, which they should have every right to be. But the government stopped certain people at the border because they interpreted some statements they had made online as being threatening to the then president, or to the current president, right? So you just want to be careful about, it's sort of like when you're applying for a job, you have to be careful about what you put out there. I wish it was not the case, to be quite frank. I wish I wish you didn't have to worry about what you say on political matters, but the reality is that the government has put more scrutiny on this. Even more important than the political matters is what you say about yourself. So on your LinkedIn, if you are saying that you are the CEO of Ontario Lake Ventures, and you don't have authorization to be the CEO of Ontario Lake Ventures, even if it's just some made-up thing that you and your friend, your roommate came up with in your dorm room, CBP is not going to care. USCIS isn't going to care that it's a made-up thing, right? They're going to take that very seriously. So you do not want to pad any online resumes at all, because it can come back to cause you some trouble. So just basically with all social media right now, you just have to be careful. And it's an unfortunate thing. It's just what USCIS and all the government agencies are paying very close attention to this. They're asking again for the usernames. So you just want to be careful, and you probably need to be more professional on your social media than your US citizen colleagues are. So just again, be very, very careful. Road ahead. You want to have realistic planning. You want to plan ahead soon. You want to get to know your employers. You want to meet with Immigration Counsel. You want to think of all alternative and creative plans. And again, it's that notion of figuring out, is it strictly important that I stay in the United States? And if so, you may be more conservative in your planning. I'm not saying politically conservative, I'm saying, from a perspective of you choosing how much risk you're willing to take. If you are just here to get the right experience, you want to be here as long as you can be, but you don't particularly care if you have to go home, then you'll be a little bit more, you'll have more options available to you of what you do from the get-go, but then you'll understand that after a few years you may have to leave. And so that's what you want to do, that's the dynamic that you want to think about. So with that, again, with immigration, you want to know what you want. You want to know in advance what you need. You want to know what's going to help you. And you have to be very, very, very careful. You want to be very careful and very particular about what you're choosing to do and what you're choosing not to do, and understand the realities of the system and how it works. I wish a lot of these things were not the case. I wish I didn't have to cut out, say, every 5 seconds, say, except for India or China. That bothers me to have to say. It bothers me to have to say, be careful about what you say politically. I don't like that that's the case. But it's important for you to know that that's the case, right? And so that's what this is really all about. So with that, I'm happy to take some questions. Actually, Sue.
Well, I have one. I wanted to share
right.
and we always have to do something. But you had mentioned to a couple of people that it's a good idea that they perhaps get some legal advice
Yes.
about their situation. I just wondered if you could tell our students what's involved in getting legal advice.
Yeah.
How that works.
So I am a lawyer, which means, what I sell is legal advice, right? So when it comes down to it, everything, in order, because we're in a capitalistic society, we all have a widget to sell, right? So if you're at a university, you're selling an education, right? That's how you're making money through tuition. If you are an engineer, you are selling your engineering services. If you are an artist, you are selling whatever artistic performance or artistic thing that you have. As a lawyer, what a law firm sells is legal advice. So if you come in for a consultation, basically, generally most law firms will charge for the consultation, right? So if it's a Miller Mayer, we generally charge $300 for up to an hour. There are variations on that, depending on who it is and how it works.
and other firms will charge you based on the amount of time that you spend. But generally, because there's a lot of administrative work involved, that'll be incorporated into the conversation. Because what you don't see when you come to meet with a lawyer is that we have a staff behind us. So as soon as you email, we have to do conflict checks to make sure that we're not conflicted out, that it's not unethical for us to speak to you because you don't have a conflicting interest with one of our other clients. We have to get you into our system, and we have to look through all of your documents. We may have to review things before you even talk to us. And all of this is time, and it's time for staff that we have to pay, it's rent for the building that we have to be in, and as much as I would absolutely love to be able to give away free services, I also have student loans that I will be paying off for the next 15 years, right? So the way that it works with attorneys is that we generally bill based on the time that we spend. With immigration, generally, at least at Miller Mayer, we can offer flat rates. So if you come in and we do a consultation, we do a sit down, we'll generally charge $300 for that sit down. And then what will happen is that if you decide that you want to move forward, we'll deduct that $300 from the flat rate that we end up giving to you, right? So generally we try to do flat rates because it's easier for everybody, right? So you're not upset that we spent X amount of time on this when really you thought we should be able to do it a little bit faster. And everybody understands what the cost is going to be. And so we try to be consistent with that. So, but then we try to give you the money back from the consultation if you end up doing more work. But if you don't do more work, we still need to pay for all the administrative work and everything else. Because we want to pay our staff. We want to pay for the building. And it's actually, I say we, I'm not a partner, so they have to pay me. So it's just the economics of our system. So basically the way that it normally works is you're a flat rate. Basically your communications are all included in talking to us. So if you're emailing, if you're calling, if you're doing all that, if you do that to excess, most law firms will say, hey, this goes beyond the scope of our representation because we're spending so much time answering questions. But a normal amount is generally fine. There are firms that charge based on an hourly basis, right? And so they'll say, this is the estimate of what we think it's going to cost, but we're going to charge you based on the billable hour rate. So if I'm doing an hourly matter, I charge $300 an hour. And that's not $300 to me, I really wish, but it's not. I don't get paid based on how much time I do. And so it's based on usually tenths of an hour rounded up to the nearest 6 minutes. And so they keep a clock going. And so you get a bill based on how much time is spent on your case. So every time you call, every time you email, every time you communicate with a lawyer at all, anytime that you're requiring the services, which is again the advice that the lawyer gives, they are going to charge you. And so that's with any lawyer that you end up coming into contact with. So when you buy a house, when you start a company, when you do all these things, that's how it works, right? So that's basically how it works to work with a lawyer. Again, we try to do flat rates so that you're not worried as much about, how much is this email that I'm sending right now going to cost? How much is this phone call going to cost? Instead, we are it's more of a flat rate that you're anticipating, and it just is generally better for everybody, I find. But that's what it's like to work with a lawyer. I have to work with lawyers every day. So I have to work with myself every day. But it is good to know. It's good to know how that works, and that it's because you're all going to come in contact with lawyers, just like you're all going to come in contact with doctors. I couldn't explain to you how doctors bill at all. That's beyond my pay grade, but and then you'll come into contact with how whatever you end up doing bills as well. So it's just important to know.
Anything else? I know it's been taking a lot of your time today, David, so I don't want to take up too much more. Maybe a couple of quick questions. Anybody? Burning questions?